So hello to everyone joining us. We will get going with this webinar shortly. We'll just give everyone a minute or so in which to dial in and join us. In the meantime, it'd be great if you can use the chat function on your panel just to let us know where you're dialing in from. It's always interesting for us to know where people are joining us from, and especially whether we've got any internationals as well, or whether we are looking at a purely Australian audience today. So yeah, if you can use the chat function to let us know where you're dialing in from, that would be great. Toowoomba, Queensland, hello. It's always nice to have somebody that's outside of the main metropolitan areas. Sydney as well, hello. Hello to our Sydney, Brisbane, all the usual suspects, Terry.
Welcome.
Wonderful. Well, thank you guys, and welcome to this webinar on interpretation and drafting. My name is Holly Baldwin from Informa Corporate Learning, and I am delighted to be joined today by Terry Reid to run us through this webinar. It'll go for around 15 minutes or so, and then we'll do a Q&A session at the end. So please, please, please do ask us any questions you have using either the Q&A or the chat tab, and we'll get to as many of those as we possibly can at the end. So Terry, a bit more about information about Terry. So he has over 30 years experience as a barrister and a solicitor, and also has been very involved in kind of training and learning across a variety of contractual subjects. He earned his qualifications at the University of Auckland and Melbourne, and has worked with a variety of financial institutions across financial law, and also has obviously worked for years in legal practice and consultancy, with training being a speciality of his as well. So we're extremely lucky to have Terry with us today. He combines an exceptional legal mind with business acumen. So welcome, Terry.
Thank you, Holly, and welcome everybody. Just to, I guess, add to that introduction, as most lawyers would, my sort of general disclaimer is that I guess the words that I will be imparting today are sort of based around years of experience and battering, I guess, of good contracts and bad contracts and the rest. So you will get my interpretation of the law and practice, and which may be quite different to yours. It may be quite different to your legal advisors, but so just take that into account. I guess I find that this is a subject that I'm particularly interested in, but I must say that just dealing with interpretation and drafting as a standalone topic is not possible. It's very much part of all of contract law, and I always think that contract law is very difficult to sort of compartmentalize. We've got to connect it all together, and I think in terms of interpreting contracts and drafting contracts, the broad knowledge of contract law certainly helps with that. And I think if I could impart some words of wisdom in 15 minutes and tell you how never to get an interpretation problem and to always have well-drafted contracts, that would be fantastic. But of course, it's not quite possible. And I do have to say that I come to this webinar a little bit wounded, because last week I received a judgment, a High Court judgment on a matter that testing some language that went against me. So I'm still sort of recovering from that. They weren't my words, but I was having to defend them, and I was sort of unsuccessful in doing so. But it highlighted for me just some important sorts of, I guess, approaches with regard to interpretation and drafting, and I'll come back to that a little bit later. So let me just say a few things, first of all, about interpretation generally, and then drafting itself. And as we say, when it comes to contract interpretation, if you never have an interpretation issue in your careers, well, that will be a great career, and how fortunate you will be. But I think that contract interpretation is one of the biggest areas of contract law where we often think our contract is providing for X, but we find that somebody else might think it provides for something else. So contract interpretation is clearly not a science, it's an art. Yes, we can look to create a body of law that helps us interpret contracts, but ultimately it is always going to come down to a question of judgment. And when you get judgment, we start to get grey areas and we get some uncertainty. And I think that one thing you want in your contracts is certainty, not uncertainty. So we can get a long way with principled reasoning, and but at the end of the day, there are limits to logic, and intuition takes over. And we all are sort of in a different sort of space around that. So the first thing I think when it comes to interpretation is to avoid it in the first place. So how do we get it? How do we get interpretation issues in contract? Well, first and foremost, just poor drafting. And after years of being involved in contracts, every week I see bad contracts. I see a lot of great contracts, but I still see terrible contracts. Too much bad use of language. Overdrafting. There's a tendency to overdraft. Let's put as much into the contract as we can. And what is the result? The result is invariably clashes between clauses and a lot of muddiness in terms of just too much. We should always be a little bit Orwellian, I think, when it comes to drafting. We should only include what we need to include. And if you can leave something out, you leave it out. So you might say, well, it's all very well for me to say that because I know a little bit about the law and I've had a lot of experience. That's true. But I think that there's no reason why practitioners themselves can't develop a level of expertise that allows them to question whether something should go in and whether we can express it in a different way. So poor drafting, overdrafting, lazy drafting. So when I mean lazy drafting, we might put in very broad clauses that'll cover everything. Well, immediately you've got an interpretation challenge. So the tighter the drafting, in my view, the less likely we're going to get an interpretation problem. Poor scope. So if you don't really know the scope of the work, and let's face it, sometimes parameters of scope are going to be a little bit difficult to define, but the better you can define scope and the better you understand that, and that's the point there about no substantive knowledge. Very difficult to put together a good contract. And I see this a lot where practitioners might be new to a business. They don't know enough about the substance to be able to sort of define a decent scope and put together a good contract. Poor instructions. When I'm drafting a contract, I'm relying on an instruction from somebody. So if Holly gives me the instruction, I want a decent instruction so I know what to draft. If I'm a good lawyer, I'll be able to fill in a lot of the gaps that are being left out by the person giving the instructions. But the better the instructions, the better. And then there's, of course, simply the poor understanding of instructions. So I get really good instructions. I don't understand them, and I develop something that isn't going to fit. And I think that when people are using lawyers, and I don't think there's anything wrong with this expectation, is if you're giving an instruction and I want this, you produce a contract, I can assume, in fact, that it's going to do the job. That's the wrong assumption to make. You do need to make sure that, in fact, it is going to do the job. Poor use of language and template use are two other points that I am particularly wary of, is that templates have become standard practice and they're fine. But you've got to remember, you've got to start with a good template. And as soon as you start making adjustments to the template, that's when you're likely to have a little bit of an issue, because you'll be throwing things out of whack and we might start to get clashes in the document itself. I don't know how many times people say to me, oh, can you just draft me a standard indemnity provision or a standard force majeure provision? Well, the answer is yes, of course I can, but is that in fact going to work for you in terms of your actual contract and what you want at the other end? So there's a whole reason, there's a whole justification, I think, as to why we get interpretation problems. So what if we do get an interpretation problem? So this is where words might be capable of more than one meaning, where we get mistakes in the document, where we get, okay, if we read this literally, this is what this means, but in actual fact, it means something else. And my pain over the last week or so has been where the literal words created a painful result. But if we looked at what the real broader purpose and objective of the contract was, we wouldn't have had the same pain. So what that highlights for me is the importance of the written word. So that when we start looking at rules of interpretation, where let's assume that it's all gone wrong and we've ended up in a court, what are the judges going to do with us? Well, the starting point is always, and I think this is a sound proposition, is that we start with the plain meaning. So if you've drafted something plainly and we understand it as in terms of how it's drafted, then that's how it will be interpreted. You're still going to, of course, have a problem if that plain meaning doesn't get you where you want. But whenever somebody has to work out what it was that the contract was intending, they start with the written word. So we can never underestimate the importance of what we write. Yes, we might have intended ABC, but in fact, you've actually written D, and so that's the starting point. So that if you want A, B, and C, then you've got to argue away from the written word, and if the written word is clear, it becomes much, much more difficult. So then, when do judges get involved? Well, judges will get involved if that there is no plain meaning or if there is an ambiguity. So typically in Australia and other Commonwealth countries is that we've had this well-entrenched sort of plain meaning rule, and we're only going to roll our sleeves up and do something about this if we have an ambiguity. And when we look at this ambiguity, it then becomes a question of, what can we look at? What evidence is admissible to help us determine what it was that the contract is supposed to say, or what those words are supposed to mean? Now, I guess, without getting into all of the detailed common law, but judges sort of define this, what we call a matrix of fact, and we try to draw facts around a matrix around what it is that we're doing, and then we can see what it is that we can actually include. Whether we can look at deletions or variations or earlier iterations of the contract or meeting minutes or whatever it is that we're trying to get in there to show what our intention is. Now, judges have typically taken this approach, and I think people think this is good news, and that is that when we're looking at the evidence and we're looking at unwinding this ambiguity, we are in fact going to take an objective approach. So we're looking at how a reasonable business person might approach this particular issue. So that's fine, but I don't like objectivity, because when it comes to contract matters, I want to be subjective. I want what I want to do. I want to undertake risk I want to undertake. So you can see, as soon as you give way to objectivity, you've got another party in there that is able to work out what a reasonable person. Remember, we might not want to be reasonable. So even though we've got this sort of backstop, it's not satisfactory, because I want to make sure that I'm getting the meaning that I want in the contract. So judges will look at language, they will look at context, they will look at what type of business we might have going on there. But the control here has always been, they're only going to intervene if there's an ambiguity. So we look for ambiguity gateways. So as soon as there is a gateway, then the judge can enter and we can start unwinding and starting to attack the interpretation of those particular words. So I think it's becoming increasingly more common for people to find gateways to ambiguity. They're not hard to find. And in fact, we may get to the point, and the High Court hasn't ruled on this, but we may get to the point where ambiguity is not needed. We can always sort of introduce evidence. That would be taking an extreme position, and that would not be good, because we get too much uncertainty. So there's a whole range of ways, I think, to try and avoid getting any ambiguity and therefore an interpretation problem. So drafting becomes much, much more important. And clearly this is the subject of a long seminar in itself. But, just as I said before, only putting stuff in that you need, the emphasis on plain English, removing all legalese, absolutely no need for it at all. Making the contract, if I look at the contracts that I guess, well, the ones I like to draft or the ones that I like to receive are those that are written in very simple language, always written in an active voice, and always are very, very clear. We get a lot of people liking to say, well, okay, let's include this clause, and we'll just open it up to allow anything that we might want in there. So we get lists, for example. You might get a list of a whole lot of things, and then at the end of the list, you'll say, or any other act, or any other event, or any other thing. Well, there's an ambiguity, because as soon as you're trying to put something into that, it's a question of interpretation. So there is often this drama about whether you go for a closed list or an open list. And you can probably gather I'm a closed list fellow because I want certainty and I trust my client to know exactly what it is that they need on the list. And remember, and for all of you that work in an area that are substance experts, you are the ones that have the greatest capacity to reduce interpretation because you know your business best. And that's the sort of discussion you've got to have with people that are helping you put contracts together, etc. So make sure when you're drafting the contract that you never lose sight of the substance. And if you have any questions, you answer those questions. I often get people saying to me, well, what happens if the contract comes to an end? Then what happens? And say, we carry on purchasing. Well, if that's a question for you, deal with that question in the contract. Actually state what happens. Then you're not going to have that gap. You're not necessarily going to have that ambiguity. So the common law itself, so the decisions judges make, and they've made a lot of decisions and a lot of very good decisions about certain types of clauses. And for those of you that know contract well, you know that there's lots of law on indemnities, exclusions, force majeure, insurance clauses, liquidated damages, termination, on and on. So the more you know about those sorts of rules, the more you're able to accommodate those rules and those gaps in your contract. So there's no substitution, I think, for knowing as much as you can around those common law rules. So drafting is what I'm a great fan of, what I call front-end contracting. So spending the time at the front end to make sure that we don't have a problem at the back end. And drafting contracts in a plain English way will, in fact, I think, reduce the interpretation questions that you're likely to have. Because yes, judges can be relied upon to fix our problems, but remember, the fixing may not be the type of fixing that we want. So interpretation is the biggest issue, I think, but it's the one that we want to avoid the most. So I think that's probably a good place, Holly, for me to stop. And I'll leave that slide for you to discuss.
Perfect. Thank you, Terry. We will go on to Q&A shortly for everyone on the line, so please do stay with us. I've had a question come in privately behind the scenes, which I will ask you, Terry, shortly. But yes, please do use the Q&A and the chat function to ask us any questions that you might have for Terry. I think, as I mentioned at the beginning, Terry does run a lot of training programs, and we're lucky to work with him on this. So please don't worry about taking this down too much, because we will send out a follow-up email on this. And we have got a number of contract law courses coming up with Terry, both online and face-to-face, and a variety of different skills levels from fundamentals through to more advanced. So if you do want any information, there's an email on the screen, a colleague of mine, shashil.kumar@informa.com, for more information. We do also offer kind of in-house and customized training as well. So if you have a group who you think would benefit, please get in touch, and we can discuss that further with you as well. So now on to the Q&A session. So the one I had come in that I'll ask you first of all, Terry, and again, please do use those chat and those Q&A functions if you want to ask a question. But the question says, if I'm drafting documents across jurisdictions, for example, South Australia and Queensland, is there anything in particular I need to be looking out for?
I guess the big thing, if we look at the body of law in terms of contract law, is it's fairly consistent across jurisdictions. I think if you're looking at different jurisdictions, the main thing that you need to be careful of is the different regulatory frameworks that might exist. If you're looking at building approvals and all of that sort of things, those are going to vary from state to state. So it's more around that type of thing. But from a drafting point of view, you're going to be able to sort of adopt a fairly universal approach to drafting. Okay,
perfect. Well, thank you for that. That was at this time the only question we did have. We will stay on the line for a minute or two, just in case you do, if anyone does have any more questions, now's the time to pop them into that, either that Q&A or that chat function. But yeah, it doesn't seem at this stage, Terry, that we did have any questions. But yeah, we'll give people a minute or two. They might just be frantically typing, who knows. I'm sorry, Terry, about I know you very well, so I know how frustrated you must have been with that ruling last week. I know that will, wounded but not broken.
Yeah, and it just highlights the judges had to interpret the words, and they did that. But I don't think if they'd looked at it objectively, I think we would have seen, in fact, that they might have come up with a different sort of an answer. But that's the way it is.
Yeah, definitely.
The problem was created by the authors of the document.
Yeah, a good learning point. We have had one question that's more around the logistics around, will the slide deck be shared? Yes, we will share over, maybe not the slide deck, but we'll send a recording of this webinar out to all registered delegates, so you will get a recording of it in the coming days. I think, Terry, that's probably it. We haven't had any other questions come in, but thank you to everyone on the line for joining us. It's been good having you for these short, sharp sessions. We're going to be doing a couple more with Terry over the next few weeks, so please do look out for your emails. We'll have another couple of these on different topics coming up over the next few weeks, and we'd love to have as many of you as possible join them for that. But yeah, brilliant. Big thanks to you, Terry. Thanks for your time, and have a great day, everyone.
Thanks, Holly. Thanks, everyone.
Take care. Bye-bye.
Bye.